This is Duke University.
Well, so now we're going to begin our discussion with the panel here, and I tell you, I've learned a lot already from the four presentations this morning, and I hope I can ask a few questions here and there and get a lot more information out of these panelists. But at this moment, I'd just like to take a brief moment and thank the Duke Intellectual Property and Cyberlaw Society for putting together this symposium today. They've done an excellent job. Okay, so to begin, I guess the first question I want to ask is, this session was, one of the titles was, AI effects on business and innovation, and I'd like each of the panelists to really just, just give a little bit of look into the crystal ball, and tell me what they think the effect is going to be on business and innovation, over the next 5-10 years of the American Invents Act. What in some things you could talk about it. I don't care how you want to do it, but some what industries will be helped, hurt by this this act, and how will it help our economy? I mean, just looking at your crystal ball. Maybe we should go first with Dr. Underweiser, since she's an in-house counsel and has probably thought, I'm sure we all think about the business effect, but she may be thinking about it more than the rest of us. And I'm just going to sit down and come up every so often and ask a question.
Well, thank you very much. I'm happy to answer the question. With there will be some uncertainty for a while, because a lot of these provisions, even if they're immediately effective, they will need some clarification through the courts to understand their boundaries, right? That's something that we'll need to see. I think for companies that operate internationally, in the long run, the steps toward harmonization are helpful, because ultimately what you want is some clarity in terms of pursuing your intellectual property protection, because it's part of your business, in all of the venues that you work in, right? We don't just sell certain products in one country and different products in another country. So you really want to see a system that has some of those characteristics. I talked a lot about the patent quality provisions. I'm very optimistic about those. I hope that as they are implemented, that we see more of this, the ability of the public interacting with the PTO to ensure that you have high quality issued patents. There is also an opportunity here to mitigate litigation. So that's something else that we're really hoping for, and again, we have to keep our minds open to see. I think that for U.S. manufacturers, the prior user rights will be beneficial. They are narrow in how they're drawn out, but I think that they will be helpful. I mean, there's a few provisions like that, but that's kind of the overall view. I mean, I would really like to see more certainty in the U.S. PTO funding as well, to know that they will continue to be able to do this important work and do a high-quality job.
So I think the question was the effect on innovation and on business specifically. I sort of take this from kind of the looking at it through the lens of small businesses, and whether the person in their garage today would be able to become the Apple 10, 20 years from now, or the Facebook, or things like that. With all the litigation, adding another layer of litigation through post-grant review and expanded inter-parties re-exam does not go in the favor of helping small businesses. There was a lot of conversation about post-grant review and whether or not there should be stronger estoppel provisions. We've taken estoppel away in some ways from expanded inter-parties re-exam and added an additional layer in post-grant. So people are getting multiple bites at the apple that theoretically could be used to run people out of money, the small businesses. The question that we got a lot, and people who complain most about the bill, especially about first to file, because the small businesses don't have the infrastructure as one guy in his garage. They need to be innovating as opposed to getting their patent together and filing it at the patent office. And if you're a big company, you have the infrastructure to do both at the same time. So it may be that the larger companies do win the race. And you absolutely see with app developers in the life cycle of an app, that's just not part of what they ever are going to do or ever going to use in the system. It's not a system that works well for them. It wasn't just the small businesses. Venture capital said the same thing. Venture capital are the people who give the money to these small startups. They think there's a problem with first to file. They think there's problems with prior user rights because you aren't able to recoup your investment quite as much if you don't know who's using it, and then you can't sue them because they were using it for a year ahead of time. So you've reduced the amount of licensing fees. So in general, my cursory, well, my maybe kind of short answer is no. I don't think it helps innovation in this country.
Yeah, I think, as you can tell from my presentation, I'm in the same boat with Crystal. I feel like I took my first real deep look at the AIA, starting about a month ago, and was going through each provision, and I came to the conclusion. And part of that was preparing for this conference, thinking, I'm going to talk about what's in it, and what I came away with is there's a lot in it, but not very much that is going to have any significant effect. I feel like there are a lot of moderately useful provisions that will help on the margins or affect things on the margins, but it's not going to change the fundamental environment for innovation. If anything, it's going to change your lives more than anyone else's lives because you have to learn a lot more than you did before, and your billing rates can go up a little higher as a result.
2,000, 3,000.
Yeah, exactly. No, but there's a level of complexity that this adds. That didn't exist previously because now we're going to operate under two systems for some period of time. But for innovation, I think that it's only at the margins.
Well, look, my name's Tom Irving. I'm a senior partner at Finnegan. I'm not a big thinker like they am. I'm from Anson County, North Carolina, and all I can say is PAFIA. Patent Attorneys Full Employment Act. It's the only business I care about. Our business is exploding now, will continue to explode, and you will explode because IP will undergo unprecedented growth in the private bar. And aren't we all glad we're here today? And God bless the AIA.
I think I'm with Mr. Irving on that. I'm as well, so I kind of agree on that. But so we have this whole set of new statutes to deal with, and we're going to have to work through. The Patent Office is going to have to implement rules, and I'm wondering, I think there's some mention of possible holes or flaws in various parts of the AIA. If anyone care to comment on what they see as an area that maybe Congress will have to go in and make some curative legislation in the short term?
May I address that? Hell will freeze over before Congress is going to touch this again for 20 years. They're sick as hell of this thing. They dealt with it since 2005. Armitage said to me, oh, well, we'll go in and fix 112. We'll actually take that out of 112A. I said, Bob, lives and being plus 21 years before that will happen. So that's the only humble, unbiased view I have on that.
Well, my understanding is that there actually is a draft of things that need to be technical corrections to the bill. And they're looking for a vehicle. The vehicle was supposed to be SOPA. And we all know what happened with that. So maybe you're right, hell will freeze over first. But, whenever we worked on bills, issues would come up that we knew we needed to correct, but we couldn't change a comma without losing support. So there were a list of those things that needed to happen, and that list exists. So, write your congressman if there's something that you want to add to that list.
And send a contribution in, and your chances of being heard will be greater.
No. Anybody else care to comment on this before we move on to something else? Or?
No, I agree with everything that was said.
Actually, it's something probably directed at Professor Shepard. You talked about Section 33 and some language in there directed to or encompassing a human organism. I practice biotech patent prosecution, so this really concerns me. What directed to or encompassing a human organism is going to be interpreted to mean?
There's two layers of problems there. The first is directed to. What does that mean? It's not defined anywhere in any statute. This is language that came in at the last minute, and you know, came in last minute. And so what does directed to mean? There's been a lot of talk about, well, it'll never be enforced as broadly as it literally says, but that's what it literally says. So if you get someone like a Scalia who will say, it literally says this. I've had conversations with the people at PubPat, not trying to encourage it, but look, if you're against gene patents, why don't you just tell the court, hey, look what Congress said. And the next thing would be the a method. Well, for them, a method to treat a disease that's directed to a human organism. The next level is what is a human organism, and I thought that bio would be really concerned with that. How do you define human organism? If you have a chimera, these things that might come in the future where it's a mouse that has human blood, that you're going to use the blood, is that at what point you consider it a human organism? And the impetus for that my understanding for that provision was for people who really felt that they didn't want stem cells to be part of our the patenting system and the political underpinnings that come along with that. But they were able to broaden beyond just their stem cell issue.
Yeah, because I'm really concerned about, directed to if it could encompass a human gene used in, another organism, as you had mentioned, in the mouse. I mean, that certainly is something that would be a big concern for those of us in the biotech sector. Okay, so moving on to other things. One thing that came up during discussion a little bit was another term that was talked about under, Tom had talked about this, relevant, under supplemental examination. Is relevant defined anywhere as far as what's, in the legislative history, or are we going to have to wait for the courts to interpret that? And I guess my concern is that the courts could start interpreting relevant to be close to material, and then we're back to the same place.
Well, never underestimate the ability of the courts to interpret things any way they want, to do as they perceive justice. These are all cases in equity, and I'll tell you, having lived through this for 37 years now, you're going to win your case on the equities. And if the judge thinks you're a slime ball, she'll find a way to invalidate your patent. And it won't be best mode, because she can't do that. She'll get you somewhere else. Now, I was taught here in this very room, in the foreordination of this room, when it was a small room, and it was evidence. I remember, because I booked that class. Tony Bocchino, my favorite guy of all time. It cost a lot of money, but I booked it. And basically, Bocchino would say, relevance, relevance, that which renders a fact more or less likely. I do not think that automatic transmission patents have anything to do with life science, and they should not be considered relevant. I also am here to propose that no one should provide anything to the Patent Office that they have not read. That is totally unfair. You've got to read the stuff. Don't give them junk. Give them stuff. I mean, I'm gonna construe relevance very broadly, but I am very much a proponent. I understand there's 2 OED decisions recently, which some people got suspended for submitting things to the PTO that they hadn't read. And I say, unfortunate, but let's not put ourselves in that position. Let's not be Jose on that point.
Anybody else care to comment on this issue? Okay. Moving on. Professor Chow had talked, about the high-tech industry in his presentation quite a bit, and it looks like the high-tech industry didn't get much out of AIA, and I'm wondering why that happened. If you care to comment, I think possibly Professor Shepard will have some comments in that area as well. We had a little bit of discussion before this session this morning about that, and I'd like to get comments on that for the group.
Yeah, I think Professor Shepard has the first-hand view. I mean, I just heard through other representatives that essentially the loggerheads that they had with pharma pretty much prevented the primary damages reform that they were looking for from going forward. Pharma was not happy with the language that was proposed.
I mean, that's absolutely correct. And there were proposals for, you wouldn't have apportionment, you'd have this gatekeeper language, and then their coalition just broke up. And if they weren't going to get what they wanted, they took their ball and went home. They're getting more from the courts than they would ever get from Congress.
Great. Well, let me shift over to our IBM council a little bit. I certainly share your enthusiasm and starting off with patents are great. I
And paying outside counsel, yes.
However, as a practitioner dealing in prosecution, I guess I wasn't so thrilled with IBM's position on a presumption of combinability of prior art and obviousness. I guess in the biotech field, oftentimes we face multiple references, 4 or 5 references getting combined, and having that presumption of combinability would be very, very problematic for us to get patents granted for our clients. And I wonder if you and the rest of the panel care to comment on some kind of position like that, as far as obviousness goes.
Sure. There's part of what's I think very interesting about obviousness analysis is that while you really want to come up with some rules and you want to come up with some expectation of where you're going to go when you analyze a patent, whether you're in court or not, right? You have a licensing discussion, you want to figure out, is my patent valid, or is the person's patent for me, asserting against me as a licensee, is that a valid patent, is this valuable? Is that you really need to look at the invention itself and the art itself. It's very fact specific, and yet you want to have some rules. So we know by looking at the jurisprudence that the way the courts have handled this, when they make themselves clear, is that they really do sometimes apply different paradigms depending on the subject matter area. And it's usually done in the context of the concept, well, especially after KSR, of predictability. You have a predictable art, you have an unpredictable art. I believe that it is relevant, and it was, in terms of how we discussed this presumption, it was relevant how the person of ordinary skill would view these references. So even if the starting point that you had was kind of put the references together, then I think it's still relevant as to what the posita can be reasonably expected to do. The other reason why we made the suggestion for this test was that what we were looking for was a way to make the argument clearer on the record. So arguably you can do that, and with some years of hindsight, this case was a while ago, arguably you can do that with some other mechanisms. You can do that by good advocacy. You can have an attorney who really does separate out the factual and the legal issues, both for the court and for the jury, and you can also do it by targeted use of jury instructions and special verdicts, so that you make sure you kind of designate what are the factual issues and what are the legal issues. The legal issue in obviousness will be much more susceptible to review and analysis if you have that even at the record of the district court. Well, okay, the jury said X, Y, and Z, and then the court takes that information and does their obviousness analysis and looks at the secondary considerations. You've got that on the record. Part of the motivation for that presumption was actually to set that up. But I don't, I actually don't think it's necessary. I think what you really need is some form of discipline, I guess, on the part of the litigants and the court to make the more explicit this analysis is, the better it is for providing some certainty in evaluating obviousness. And that's going to be true for examiners as well. That's going to give them some guidelines to work with. But that's where I think the problem is. To the extent, you don't want to go all the way to obviousness or non-obviousness invisibly. It's really a problem that requires understanding the technology and sifting through the art and the claim. And I think that explicit analysis is more important than anything.
I certainly agree. We're in sort of a period of uncertainty. Exactly. What you need to argue or prove, as far as obviousness goes, and it's difficult. I guess for those of us who practice in the biotech area, we often face where it's an unpredictable art when we get rejections of claims under Section 112, and then we go into obviousness, and the reference is cited against us. The art's not unpredictable anymore. So it's sort of this dichotomy that's a problem for us in that area. Well,
you have a similar problem. There's a very interesting interplay here because one of the things that prompted some of the written description jurisprudence, in my opinion, is things like the deposit requirement for enablement, because it left the courts and the PTO with you know, a presumptive satisfaction essentially of 112, even in situations sometimes where they felt like the specification might not be sufficient. And you can argue that that led to some of the 112 case law. And in my view, you have a similar reflective problem in IT, and in particular in some software patents, because what you have in the jurisprudence is an assumption that any of the software, that your POSITA it's unclear if it's matching up between 103 and 112. So very often what you end up with is any old thing that you could file. We don't do this, but I had to say that. But any old thing that you can file sometimes may be regarded as sufficient for 112. You don't want that. You don't want the court or the PTO looking at a software invention and saying, well, I had 3 pages of spec, that's enough. I mean, you invented a new compiler. I need more than 3 pages of spec. So you end up with a genius POSITA for 112, and then shouldn't you have the same genius for 103?
No, but you want a moron.
Yeah,
yeah, you want to say that for
then
103
you get a moron.
that's a moron, you know, not
yeah,
going to do anything.
So you have, so it's very interesting. In biotech, you have a setup that is, you have a similar tension, because you have a problem that was intrinsically set up, I think, by some special rules with 112, and then you have a parallel problem it's related because the 112 jurisprudence started moving into IT with lizard tech, right? But you have this related problem in software, and I think part of it is a POSITA problem.
Let me add to that too. I think you should not even be considered for bar membership if you ever let the word predictable out of your mouth or in a memo about an invention your client's doing. Marion, that's death. Look, you got to start from the get-go that everything you do, it's not predictable, but don't go down the road David said either. If it's too unpredictable, you got a huge problem. Starting on March 16th, 2013, the same day that we consider obviousness will be the same day that we now consider written description enablement. It's at the time of the effective finding of the claimed invention. Before we can sort of wiggle a little bit and say, oh, well, yeah, you know, we made the invention, it's really obvious, but by the time we filed, oh, you know, it was really clear. Bull feathers. That ain't going to work anymore. I refer you to Martens et al., M-A-R-T-E-N-S, Santa Clara Law Review. Last year, it's an article I co-wrote with 4 brilliant young lawyers from our firm. They only hire people at 100 IQ points smarter than me. The problem is that's not much of a standard. But I would say read that. If you want that article, irvingt@finnegan.com. I got to go to work here this afternoon. Email me and I'll email it to you. It's easy to email. Martens et al., Santa Clara Law Review. We go into a lot of the points that Marion has so well articulated.
Great, thanks. Anybody else want to comment or move on? Okay. How about best mode? Let's talk a little bit about best mode. So now we have a situation where the new legislation puts best mode is not important for validity and validity analysis, right? But we're still required as practitioners to include best mode in the patent application.
When I got here in 1974, we just come through the Vietnam War. A lot of us had marched. Kent State was very recent. We used to have an expression. Is bullshit one word or two? That's my view on the current state of the statute with respect to best mode. And we differ, with all due respect.
And all I'm going to do is I'm going to refer you to an article I wrote for Patently Ill, explaining, not defending, why there's a dichotomy between use in litigation versus use in prosecution. There's a difference of opinion, and it's just going to get heated.
I guess the Patent Office put out a memo somewhere early on, September 20th, I think, about that they were still going to, enforce best mode in patent applications.
Well, yeah, the whole point is to encourage disclosure. And if you are going to encourage your clients to lie to the Patent Office, then that's what some people are saying they're going to do, because there is no obvious ramification. But there are obvious ramifications. I mean, there are things that are already in the statute that if someone lies to the Patent Office, you're in violation of your OED rules. I mean, so. Go ahead. And there already was a provision in law that the DOJ could go after you. So, go ahead.
Well, I just want to make sure that we framed it, because you mentioned best mode, but so just that everyone knows, best mode is a requirement under Section 112. You have to disclose the best mode. Up until the AIA, best mode was also a defense in the patent infringement litigation, meaning you could raise it as a defense. If you showed that the patentee failed to show best mode, the patent was unenforceable. In the new patent reform, the new statute says you can't raise it as defense, but yet leaves it in Section 112. The debate is, well, what good does it do if you can't, if it's no longer enforceable in litigation? No one knows during prosecution whether or not the best mode is disclosed, because the prosecuting attorney is not going, hi, I've hidden the best mode, so we're just going to give you the worst mode. Yeah. So Professor Shepard's article, which I've actually given to my class, explains why that there's at least a reason, that they suggest, she suggests that that other mechanisms can sort of force folks to comply with the best mode, namely that there's sort of disciplinary possibilities with respect to those folks who later don't comply with it. And then I think there was a critique from Professor Chang from George Mason, who suggested that that wasn't going to work in sort of more graphic language. It was Congress lying, or are they stupid, or something?
Yeah,
something like
right.
that.
Something like that.
And so, and I would suggest to you that most of you as ethical attorneys will actually try to comply with the best mode requirement, but what may happen is there is actually some effort, that there's actually reasonable diligence that is necessary to comply. For example, you may get your invention disclosure, you may interview an inventor 3 or 4 months before you file. The best mode disclosure requirement occurs upon filing. Now you don't really have the incentive to be careful and check that things have sort of haven't evolved, so that we're not talking about fraud, we're talking about being a little more careless, and that may be a possibility that sort of escapes now with the current amendment.
My complete and humble views on best mode are set forth in the article that's sitting outside of this room that I turned into AVA to be published with my co-authors 2 days ago.
Thank you, Professor Chapter, going through and backing up on that question and putting it in its proper context. I guess I recall there was a Director Kapos was in an AIPLA sponsored webinar on the 30th of September, and in that webinar he had said that the Patent Office wasn't going to be concerned about best mode anymore. I mean, but that memo that was put out that the examining court 10 days before said they would. So I don't know if it's certainly what the Patent Office is doing on that right now.
Well, there was a lot of talk. You don't want the Patent Office to be the police force to figure out if they gave best mode or not. It's just a matter of disclosure, and you're supposed to disclose. If they don't, then are there ramifications? Yes. Will they actually be utilized? Perhaps not. But
well, maybe at this time we should open up some questions to the audience. I've got more, but if the audience has some questions, somebody.
I actually wrote a note last semester on best mode.
That's the one thing everyone cares about is best mode.
Way to go, Stu, you're timely.
I made some reference to Professor Shepard's Patent Leo post, but one question that I have on it is, for each of you, do you feel that the best mode requirement does encourage, in fact, better disclosure? Does it result in better disclosure than if the best mode requirement isn't there?
My personal practice, yes. And I'm continuing to tell people, disclose the best mode. That's what the article says. And it really does enhance the disclosure. It enhances it for enablement. It enhances it for commercialization. There's all kinds of good reasons to disclose the best mode. And I'm going to continue to believe it's a statutory requirement that would have a penalty, and try to get my clients to do it, because as Professor Shepard pointed out, who's going to get nailed? OED. They don't bring your client for OED? That's you, Jose.
Exactly.
Somebody else? Yes.
Since you just brought up Jose again, we've mentioned inequitable conduct a couple times and how maybe the statute didn't address it. But what do you say about the changes to 288 and how that will change inequitable conduct?
May I? Okay. May I? Not that I like to interject. 288 could be the most fundamental change in American law in a long time. 288 is like 251 and like 116. The Congress went through it. I think Professor Shepard would know more about this. But what they took out intent. They took out the intent to deceive from every statute. They went through and cleansed the whole thing. So 288 is not there. And what 288 says is it says basically if you've got a valid claim and an invalid claim, you can enforce the valid claim. Now there's some very interesting legislative history, which I just so happened to write down this morning. Congressional record, March 18th, 2011, Senator Kyle. Who knew that Senator Kyle was such a genius about patents? And I'll be darned, he said for purposes of this statute, inequitable conduct means the same thing as validity. So some of my friends are taking what I think is an amazing position that the amendment to 288, which will be effective on September 16, 2012, will legislatively overrule the fruit of the poisonous tree or the infectious inequitable conduct I alluded to. That is going to be a hot litigation topic. If that's the case, even at my advanced age, I'm coming down to Duke and I'm going to do back handsprings on the front lawn for the benefit of all of you.
Yeah, I mean, what we've sort of been talking about, you know, Jose over here, best mode and inequitable conduct. What do you have to say about the potential conflict of interest between the client and the attorney now, and that, you know, you're holding the attorney responsible and not the patentee, not the patent? They have reduced incentives to disclose as much as they may want to, and you're left holding the bag. How, you know.
I mean, I think that's fairly easy to address. It's not addressed yet, but I mean, just put in the inventor declaration that they have to disclose the best mode. So you put them in sort of, you make them a Jose, so to speak.
But they don't get dragged before OED. You do, JP. Yeah, it's going to be your rear end on the line before OED. I have a situation once, 30 years ago. I had a client that said they wouldn't disclose the best mode. And they were at that time $1 million a year client, which at Finnegan 30 years ago, that was a top 5 client. And I said to them, I made sure none of my partners were in the room, I said, this Jose ain't going to do that. I'm not filing this case. And I hung up on him. So the people in the room were horrified. And they said, these were associates, they said, moron. They said, we're going to lose that client. And I said, you going to sign the paper? And I said, now you watch. They'll call back in 15 minutes, and they'll tell us to file it with the best mode, because we do a lot of good things for them. Yeah, right. 15 minutes later, almost it's like I had it orchestrated. They called back, they said, we reconsidered. We think you misunderstood us. We've always wanted to disclose the best mode. And so I had the paper ready. I filed it. I ran the runner to the patent office immediately before they could change their mind. And I got the thing filed. But I think you Jose's out there, and I'm a Jose, I'm like the grandfather Jose, I ain't going to do it. I ain't going to do it if it's wrong. And if it's wrong, I am an officer before the United States Patent and Trademark Office. I'm an officer before the bar of the District of Columbia. I am not going to do it. I haven't spent 38 years to end it in a scandal. And so the client can eat quiche, pound sand, you fill in the blank. I don't have any strong views on that.
Any questions?
I have a question for Professor Chow. I was curious in what some of the rumors you've heard around Silicon Valley are. If they didn't get what they wanted out of the AIA, what's the backup plans? Is it the courts? Is it copyright?
Not copyright. No, I mean, I think it was just. I don't think they have a backup plan. I think there's frustration about patent reform from the legislative side, but they feel fairly good with respect to how the court reform has gone. I would say it's a little. I mean, they've gotten significant court reform in the last 5 years in any number of decisions that I think that they're very happy with, and I think they continue to hope that they will get more. I think that you'll probably hear in this afternoon's discussion really where their primary focus is now, which is, I think, a lot on the remedies side. And I think that you're seeing corporations consciously put up test cases to try to test certain things. I4I was an example, didn't succeed. But they are thinking about different ways to sort of test remedies and push back on the way the damage awards.
So do you think that the expanding the peer-to-patent system is actually going to provide some kind of beneficial effect, or it's just going to create a bunch of noise for examiners and they're going to pretty much ignore the submissions?
I really don't think so. I think for people to participate in the system, you're doing some extra work, and you have to feel like what you're doing ought to have a positive outcome. The statistics for peer-to-patent, which are in their annual, they have a couple of annual reports, show that in a lot of instances in running the pilot, the examiner either the examiner's actions were affected by or actually resulted in amendment or cancellation of claims. And so the examiner picked up on art that they would not have otherwise found. And this is something that occurred in particular with non-patent prior art. Now, you could say that in that respect, it may mean that ultimately that will encourage the examiners or the examination system to learn how to pick up on the non-patent prior art better. So that's also a possibility. It will maybe guide things in that direction. But I think the reason why I think you're unlikely to have the noise is because people will focus on the applications they care about, and if they really want something to happen, they're likely, they're doing extra work, and so the submitter is likely to submit something they think is actually going to make a difference. I think that's really, so you have the experience which shows that this is, at least in the pilot stage, that this has worked effectively. And I also believe that the Patent Office has shown tremendous willingness to work with the patent community on systems like this. And so if the way that the processes work and whatever system is set up is not achieving everything that it can, I think that will come out, and I think it is quite possible that the Patent Office would be receptive to changes that would make it work better. One of the areas that, I didn't mention this when I was going through the slides, one of the areas that we think is important here is actually university outreach, which includes law schools and engineering and science students, because very often it is the non-affiliated expert who is in a more comfortable position to be submitting art. Now, you can be anonymous, but the point being that you can really evaluate the art. You're not concerned about looking at applications. You're not concerned about maybe what you say about it. You don't have a client to worry about. You don't have an employer necessarily to worry about. So the PTO does have established relationships with universities, and we're really hoping that can be used to help find, recruit, sensitize students to participating in the system. So we're very optimistic about that. The pilots have been working very well. And there are pilots all over the world running this kind of a system. So we're optimistic about it.
I do have a concern, I'd say. I do think that patent examiners are overworked already. They have a count system where really they have to get a certain amount of things through. And between peer-to-patent and third-party submissions, you're giving more information in front of them when they're already in information overload. So, I mean, I think it's a good conversation to have, and I wonder how it really will affect the actual practice of the examiner. Are they going to look at 10, 15 more submissions per application? And if it's a technology that people care about, they're going to get that many. I do worry about that.
And Professor Shepard's worry is right on point, because think about Theresence now. To the extent that en banc ruling is followed, you are benefited by disclosing as much as you can to the Patent Office, because if they allow the claim, well, it couldn't have been objective but for material. And so this is what I fear. I see this tidal wave coming of very dedicated government employees just being whoosh, like the tsunami. They're going to get overrun because now with Theresence, I mean, it's crazy. It's crazy not to get everything you possibly can. I mean, don't put automatic transmission art and you read everything you submit. But gosh, you got to get it in, because then you go to litigation, you're essentially insulated from all that because it's already been considered. And I know Professor Shepard was kind of bothered by that the court's going to give all that deference to the Patent Office. But I think that's where it's headed because of the Theresence standard. So I think we're headed for a big problem. And if we need anything, we need the resources of the Patent Office to be at least doubled if not troubled, and to have a whole lot of money go there. And if this country is serious about getting its economy back on the right track, I don't know a better place to start than the Patent Office. And with that, I announce my candidacy for 2016 President of the United States. Thank you.
So do you think that there, since it's changing the practice? My impression was that folks were already over-disclosing. You think they're more over-disclosing even more after this?
Yes. Yes, for that very reason.
Okay.
Because, whoa, it's like, blessed are you if you over-disclose, as long as you're not putting something stupid in there, you can get hauled before OED. Blessed are you.
Ian, I guess what I would say is, I think what, in talking about TheraSense, I think the promise of a decision like that is meant to restrict the situations where a patent could be unenforceable, and this just remains to be seen, it's an open question, is whether the Federal Circuit comes out with opinions that make it clear what is or is not necessary for the PTO to see. So if they get, if they get one of these, McKesson scenarios where someone argues that there was a related case, it may not be that related, right, and have none of the same inventors and have been filed years before or years after. But if they have a situation like that presented to them and they make it clear what is or is not relevant in those circumstances, that could actually limit. So I think it remains to be seen. I understand the point and the insulation point, but I think it's possible, given how strict the standard is, that may actually limit people's feelings of need for flooding the Patent Office.
We hope so.
So, exactly.
For my full views on that, see the Virginia Journal of Law Technology, September of last year, that I co-wrote with, again, some brilliant people from my firm. If you need it, I'll email it. But we went into those very points, because I was afraid the bar was thinking, oh, TheraSense, it's all over. Tell that to Cephalon.
Other questions? Yeah, I think we have a few more minutes. I have some more questions, and I'm glad to. I think Professor Shepard touched on this a little bit, regarding the new 102. So we've gone to a first-to-file system, but we also have this grace period for disclosure by inventors, and that there may be some advantage to disclosing first before filing, at least as far as it goes for U.S. rights. And Carrie, you can comment on this, Professor Shepard, and other members of the panel.
I mean, obviously, if you're going to get international rights, then you have to look at this a little bit more in depth. But one of my problems is that one of the impetuses was you want to harmonize, and that we needed to harmonize. However, most companies were already working in this world where they knew what was going on internationally, what you could and couldn't do, and what you could do nationally. And when we bring in this new system that kind of throws the whole thing kind of up in a state of unrest again, I don't know that we really were losing out on innovation by keeping our system the way it was. And I haven't really been convinced by the arguments for changing the system midstream so that we have 20 years of operating kind of in both systems and not really going to a first file system because of the grace period, and the weird language in there makes it unclear. So I'm not answering your question. I'm just saying that I'm still confused.
I agree with Professor Shepard. I think those exceptions are traps. I really do. I mean, those are traps. And I also disagree, and again, respectfully, because my mother taught me to be respectful when I'm at least face-to-face with people. My full views in the ABA article is it's not a first disclosed system. You can never be worse off filing first, and you're often better off. And that's all developed in the article that's sitting out there. And take Professor Shepard's view, take my views. That's why you're law students. You have to learn to distinguish between the two. But those exceptions, those are traps. Yeah. Those are traps, and they're not very good.
Until we figure out what they mean, absolutely.
Yeah, so I think the way I like to think about this is to distinguish between the process and the ideal of where we really want to go. We're in a global economy, and if you think long term, there are a lot of good reasons to have some harmonization in our patent systems. If the commerce is global, then it makes a lot of sense for a lot of reasons to have a global or more harmonization in the patent system. I'm not saying global patent system. One of the reasons is a very simple one, which is that the numbers are so high, the patent offices around the world, and innovation life cycles are so fast that enabling work sharing is really important. And when the rules are a little closer, you can enable work sharing and you can speed things up. You're also going to speed things up and make things a little easier for companies, inventors. Some inventors who are small inventors decide they want to counterpart their applications because they understand that they may have a bigger market globally. So there are a lot of reasons why you can achieve certainty and a better system if you have some harmonization. Now that said, that's an ideal. And when we look at what happens when you make modifications like the kind of grace period that we have in the AIAs, there is absolutely some uncertainty inherent in what just happened. It is unique. So we know that we have absolute novelty in a lot of countries, but we know something else. We know, and a lot of the inventor community wanted some kind of inventor grace period, right? So there's at least a perception that if it works right, that it can work well with people's business models. Well, I get to go and show my prototype, something. Okay, so there's a reason why people wanted some kind of grace period. I think for IBM, we like the idea of having some kind of a grace period. And part of the issue with harmonization for the US has always been our credibility in coming to the table. We had this unique first to invent system. And so now we've said, okay, I'm going somewhere towards first to file. What good is this going to do me? Because I've got this odd grace period. Well, we already know that Korea has now adopted a grace period. We know that they have moved in the direction that we're going. That we have some credibility now at the table when we talk about harmonization, and that's really important. Now, that said, what about this interim period where we're sitting here with this first to disclose setup? What is this going to mean? What happens if you have intervening disclosures that aren't exactly the same as yours? What's going to happen? I don't know. I mean, right? I don't know. I mean, the courts are going to look at this. They're going to make some sort of decision. The only certainty that you would have is if you file before you disclose, is if you treat it like absolute novelty. But the hope is that when it plays out, and you can have expectations of risk, right? You can go into it and say, well, I think this was okay, but that's not okay. And we'll see how it plays out. Once it plays out, we'll have a better idea of what works and what doesn't work under US law. But the point of this step, the bigger picture here, was the idea of being able to reach some level of harmonization. It may not work, it may end up being impossible, but given the fact that most people, if you look at the interference numbers, you can see, and maybe the prior invention litigations in court, and when the junior party succeeds, you can see that it doesn't play out very often as being important, the idea of the first to invent. It doesn't save a whole lot of inventions. So maybe, and so you say, well, so what? Maybe it didn't matter that we went from first to invent to first to file. It remains to be seen how this is really going to play out, right? Is this really going to make the difference it needs to make? But for a good 50, 60 years, there has been a recognition that for us to be playing better economically, internationally, that this is a positive step for us. That first to file is a positive step. Now, where it ends up going from here, I don't know. Will we go to absolute novelty? I don't know. But that's really, I think you have to recognize the incremental step and where we were trying to go with it. And maybe other countries will adopt a grace period.
And just remember Professor Chow's comment to supplement that is, this is all going to go on until at least March 15th, 2034. You're going to have to know both laws. My view is with pharmaceutical patents and patent term extension, it goes on to March 14th, 2039. And in view of the Jedi Master Mixer, which we have not elaborated upon today, can go on a lot longer than that. So you're going to have to speak both Greek and Arabic. You have to do the 52 Act. You have to do the new one. It makes you so extraordinarily valuable. Again, God bless AIA.
Well, yeah, on that note, it's probably a good time to close the session.
Produced by Duke University. Online at duke.edu.